This is an act that the President signed in 2002. Before that time, and during the time I worked for the Immigration Service and when I went into private practice, if a child aged out, that turns 21 years of age, all of a sudden the child had to be separated from his family. And the Child Status Protection Act tries to eliminate that. The first thing we're going to talk about is called the freezing of ages for immediate relatives. It provides in the act the age is frozen upon one of three different parts. Number one, if you're a citizen and you apply for your child, and a child is somebody who's unmarried and under 21, before that child's 21st birthday, that child's age is frozen. He's 20, he's 19, his age is always going to be 20 or 19 for the purposes of the immigration laws. Number two, if you're a permanent resident and you apply for the child, but before the child is 21, then you naturalize, the child's age is frozen also below 21. And then finally, if you're a citizen and you're applying for a child who's married, which would be the third preference category, and then the child's spouse dies or they get divorced or the marriage is annulled, if the child is still under 21, he's considered an immediate relative. So we have these three circumstances where your child is frozen in as an immediate relative. Why is that important? Because immediate relatives can come in unlimited numbers to the U.S. and get their green cards. And if your child is over 21, it will take you years to get that same child a green card in the United States. So this is very important. Now, a lot of people ask me, well, what happens if the child doesn't come right in and he's 25, 30, 35? As long as that child stays unmarried, he's still considered an immediate relative. That's the beauty of it. And then other people ask me, there was a new law passed in 2009, and what happens if the parent dies before the child comes in? If the child is in the United States when the parent dies, the child can still adjust status to permanent residence. So those are three really important rules to remember. So what happens if you're not a U.S. citizen, so you can't freeze in your child's age? What if you're a beneficiary of a petition that's either filed by a relative or maybe filed by your employer? You're considered the beneficiary of that petition. Your child and your spouse are considered derivative beneficiaries. So that's what we're going to talk about in this segment. For derivative beneficiaries, the Child Status Protection Act establishes a mathematical formula that may keep your child's age below 21 and enable him to immigrate along with the family. So what's the formula? First of all, you start with what is the child's age when the priority date becomes current, so you can apply for a green card, or if the priority date's also already current and there's a petition and you're waiting for the petition to be approved, it's when the petition is approved, whichever one of those two dates is the latter. Then you just do a little subtraction. You subtract the amount of time that the visa petition, which is usually going to be an I-130 or an I-140, there's a couple other forms too, how long it was pending. Not how long you were waiting for your priority date, but how long the petition was pending. And you subtract that number of days from the child's age when the priority date becomes current. And there's another little trick that sometimes people don't realize, but if the petition was pending or approved before September 11, 2001, and the child was under 21 at that time, you can subtract the amount of time, well, you can subtract an additional 45 days. Okay. So if your child is 21 and you say, too late, but the petition was pending for 5 months, and you subtract the 5 months, and it brings your child's age down to 21 months and 21 years and a month, that 45 days could be really important, because then it'll bring the child's age down to below 21, and it freezes the child's age. But here there's an additional requirement, that the child must seek to acquire a green card within 1 year of that date. What does seek to acquire mean? The State Department, the Immigration Service says, he's got to file the application for adjustment of status if he's in the U.S. If he's out of the U.S., the parents must file an 824 so that child can follow to join, or the child must start the application for an immigrant visa. However, there's some cases by the Board of Immigration Appeals that says the law doesn't say file any application, they just say seek to acquire. So there was one particular case where the parents hired an attorney to get the child a green card. The attorney didn't do anything for over a year, so the child didn't seek to acquire in the immigration lexicon for a year, but the BIA said hiring the attorney was seeking to acquire, and that worked. What happens if the child marries before the child gets the green card? No longer a derivative beneficiary. What happens if the petitioner, like your sister who was the citizen who applied for you to get a green card, dies before the child gets his green card? Doesn't matter if the child's in the U.S. and is adjusting status. What happens if the principal parent dies? Same thing. If the child is in the United States, the child can still adjust his status. Now, what happens if after you do the math, the child's still over 21? We're going to talk about that in a minute.